30 by my watch, so we're going to kick it off. This is Eric Hauge from Homeline, Executive Director of Homeline. And on today's webinar, Mike Bra, our Managing Attorney, will be answering questions that have been submitted in advance and also over the question and answer system built into Zoom. Before we get started here, just another quick introduction. Homeline is a statewide nonprofit organization. We provide, our main program is a free legal hotline. We provide legal advice, advocacy, and education services for renters throughout the state. And we've advised approximately 250,000 renters since opening. Our hotline is available in 4 languages: English, Spanish, Somali, and Hmong. And we are staffed by housing attorneys, tenant advocates, organizers, and public policy folks, as well as an army of volunteers and interns. We'll leave this up on the screen for part of the training and then kick it over to Mike. Again, this is how you contact our free tenant hotline. And you can also submit questions if you are a renter directly on our website. If you're a service provider working with a client, we also can advise you. We try to set things up so that we can speak to both the advocate and the tenant at the same time. You can submit those types of requests over our hotline or via the internet on our website there. So again, today's format is going to be a little bit different from last week. If you joined last week, and if you did or didn't join last week, the recording of last week's video is available on our website, so you can review that. We had a lot of questions submitted in advance for today, so we're going to get to those first, and then you should be able to submit questions live via the question and answer tool built into Zoom, and Mike will see those and get to those after we answer the questions submitted in advance. So with that, I'm going to hand it over to Homeline's Managing Attorney, Mike Bra, to kick us off.
Thank you all for joining us again today, and welcome to those of you that this is your first time watching this. We plan to do this on a weekly basis until the world settles down, the landlord-tenant world settles down a little bit. Quick recap. At this point, landlords unable to file evictions for almost any reason. Non-payment of rent, unauthorized occupants, any kind of standard breach of a lease, like having a pet when you're not supposed to. A landlord cannot file an eviction for those reasons. That rule is in effect currently through May 13th. It's tied to the peacetime emergency that the governor has issued through executive orders. Will that be extended? We don't know. It has been extended once already by the governor, and it's maybe likely or certainly possible that it will be extended once again not later this month, but in a couple of weeks. The other couple main topics that we talked about last week were privacy, when a landlord could actually get into a rental unit if the tenant doesn't want them in, especially for showings. We have actually created, I think we posted it since our webinar last week, a position paper on when the landlord can actually enter and what rights a tenant has in the COVID-19 era on saying, no, landlord, you can't come in. And the last one is tenants are allowed to move. Tomorrow is a very big moving day in Minnesota. As we all know, moving tends to happen during the warmer weather months for obvious reasons. Nobody wants to move at the end of January. So we will see tenants moving in U-Hauls tomorrow. That is legal despite the shelter-in-place order. The governor explicitly stated in the second version of the shelter-in-place order that tenants were allowed to move into new homes, as are people buying a house. So that is sort of a recap of the 3 main things. There have been no significant changes in the law since last week's webinar. Our plan is to every week mention sort of the quick status of landlord-tenant law as it's related to COVID-19 issues, and if there are new rules that are created, to pass them along to everybody watching. But today, we're trying to answer questions. That's what we're hoping to do with the majority of this time. some of which, as Eric mentioned, were submitted either last week or prior to this week's session. And then we should have time for lots of questions. So either in the question and answer box or in the chat, we'll get your questions and hopefully have a chance to talk about them as we go through. Now, obviously, some of those might be answered by the questions that we'd had submitted already. So you might want to listen to the first 3 or 4 questions before you type yours in. But hopefully we'll be able to get to your specific questions too. So Eric, if you're ready, you can fire away with the first question.
All right. Can you clarify limitations on rent increases during the pandemic?
Sure. So there's another executive order from the governor that talks about price gouging, that a landlord is not allowed to price gouge. It's not just landlords, it's all kinds of providers of goods and services. Housing is clearly listed in the price gouging rule, executive order listed by the governor. So the rule that the governor issued has a 20% automatic sort of trigger of the price gouging standard. That's not the only standard that the governor included, though. They said that if it's, I can't remember the exact language in front of me, but if it's a substantial increase over the comparable products that are available within 30 days prior to the peacetime emergency being issued, then I think that it can be considered potentially price gouging. The Attorney General's office is tasked with enforcing the price gouging rule. And it's got a substantial penalty. I believe it's up to $10,000 is the penalty for any price gouging per transaction. So if you have a landlord that raises everybody's rent 30% in a 100-unit building, it could be a massive amount of money that they would be potentially fined by the state. Still
Next
with us, Eric?
question. Yep, sorry.
Yeah,
Next
that's all right.
question. Can renters trade skills for rent? For example, lawn, paint, clean, office.
Yeah, tenants do this a lot, actually. Pre-COVID-19, during COVID-19, you'll see ads in not the paper, because nobody puts ads in the paper anymore, but online and elsewhere where landlords will offer discounted rent if a tenant agrees to take care of the vacuuming the hallways, work outside, sometimes even leasing the place up. And so it's perfectly legal for a tenant to exchange work for all or a portion of their rent. Happens a lot. I would guess maybe 1% of tenants in the state pay some portion of their rent through labor at least. Landlords are also supposed to, by law, again, this is pre-COVID, this has been around since the 70s, pay a tenant for doing any work on a regular basis, including something like lawn mowing and snow shoveling. If the landlord requires that a tenant does that work as part of an agreement, they're supposed to say so in writing. They're supposed to pay the tenant, and it's supposed to be a fair price. It can't just be a penny for taking care of the sidewalk all winter. It's got to be a fair sort of market-based price. And again, that rule's been around for almost 50 years now.
A client who has multiple lease violations and the landlord wants them out on May 30th. Is this legal?
So the short answer to that is it depends a little bit on the governor's decision to extend the order or not. If the governor extends the current moratorium on evictions and terminations of tenancies, then no, that wouldn't be something a landlord could do much about. If the tenant is still there on May 30th, or 31st, I should say, and the governor has extended the moratorium on evictions and tenancy terminations, then the tenant would be able to stay. We're going to see that a lot in the next couple of days. Landlords have given notices where the tenant is supposed to be out by the end of April. And if they're not gone, the landlord's normal remedy in that situation is to go file an eviction claiming that the tenant is what we call a holdover tenant. It's one of the things that you can check in an eviction box. It's not a common reason for an eviction, but it is a reason for evictions that's filed. And that would be the allegation. However, on May 1st, a landlord can't really do an eviction for a holdover tenancy. They're kind of stuck with that tenant going forward. So the answer to that question about May 30th is going to hinge completely on the governor extending the peacetime emergency or not.
And again, that timeline is that the eviction order is 20-14. That was issued in mid to late March. It is that order is reliant on the governor continuing to extend a peacetime emergency, which at this point is through May 13th. So in theory, he could extend. He could make a decision to extend it another 30 days into June. The next question, can a manager landlord evict after the emergency is lifted for the tenant having an unauthorized occupant stay during the pandemic?
Yes, a landlord could certainly try to file an eviction for a breach of the lease. Probably the most common breach of lease eviction that we see filed in Minnesota is for an unauthorized occupant, is what it's usually referred to, or somebody that's not on the lease living in the rental. I'm trying to think sort of what would happen. Let's say that the governor's order ends in mid-May and the unauthorized occupant runs out the door the day the governor's order expires. Would the landlord be able to file an eviction at that moment for an unauthorized occupant? It might be a tougher case for the landlord to win, especially if they've accepted rent for May. I suppose the landlord, if they really want to maintain their right to evict the tenant for an unauthorized occupant, would be probably well advised to not accept rent for May. As you can imagine, most landlords won't go that route. They want to get the rent. And it's probably unlikely that the unauthorized occupant's going to run out the door the minute the order is up. But I can theoretically see where it would be a messy legal question. But the short answer is, if the unauthorized occupant sticks around, then the landlord can eventually evict for that reason after the order is lifted, yes.
What are someone's rights as a tenant when they are renting a room and do not have a written lease?
A written lease is not especially necessary in Minnesota to establish the rights of a tenant. All that's really required is that somebody owes rent for occupying a space, and then they fall into the literal definition of tenant. Minnesota defines landlords and tenants in law. There's a statute that actually says what a landlord and a tenant is. So not having a written lease wouldn't be that important for the question of, do they have the rights of a tenant? They'd still be protected by the eviction moratorium and all the other protections that are in place right now.
Do certain rights of private landlords differ from others?
To some degree, yes. There are some city rules that are specifically targeted towards buildings where the owner does not occupy the space, for instance, like if somebody's renting out a room in their home. Not every city has much for exceptions to that. In general, the short answer is no. Almost all of Minnesota landlord-tenant law still applies to even somebody renting a room out in their home. Like I said, there might be some city exceptions where the city has different rules about their licensing requirements than they would if it's a landlord renting out a fourplex where they don't live there, for instance.
I mean, the one kind of big exception right now is the Federal CARES Act, which does impact kind of an unknown number of private landlords. That eviction moratorium is clearly extends until late July and bans the charging of late fees.
Right, and we didn't talk about the CARES Act at the beginning of the day. We've been talking just about state law. The CARES Act that Eric just mentioned is a federal rule that was put into place late in March that said that evictions can't be filed for non-payment of rent through July 25th. And at that point, the landlord would have to give a 30-day notice, essentially saying what's due before they could file the eviction. And the big question is, who's covered by that? Pretty much any building with any kind of federal subsidy involved, even down to something like a Section 8 voucher, is certainly covered by the CARES Act. But if there's a federally backed mortgage in place for the homeowner, then the CARES Act also is triggered. So that could be a lot of landlords and tenants in Minnesota. Our best guess right now is somewhere between 30 and 50% of landlords are covered by the CARES Act. which would make for a really messy situation legally if the governor does not extend the eviction order, because some of the cases would be fileable, some of them would not be fileable going forward. So we'll see what happens with the governor's decision to extend the peacetime emergency.
Can a landlord charge for hazmat, hazardous material cleaning services after a tenant has moved out, even though the tenants were not sick with COVID-19?
Yeah, that's a different question. I'm not sure that a landlord can charge extra necessarily, even if the tenant did have COVID-19. So I think what they're really asking about in this question is a security deposit statute in Minnesota, which is one of the ones that we've dealt with forever, a lot. It's in the top 3 reasons people contact us most years. Security deposits are sort of a back burner issue these days, but if a landlord wants to keep a security deposit, they have to show, and the burden is on them, that the tenant caused damage to the rental beyond ordinary wear and tear. That's the legal standard. It's a very vague standard, and I'm not sure how it's going to play out in the COVID-19 era, because we haven't seen tenants arguing about security deposits yet, because honestly, conciliation court is closed more or less right now. There are priority systems set up in the court and conciliation court, which is where tenants tend to sue for deposits, and rent escrows, where tenants try to force landlords to make repairs, are essentially unfileable right now. I mean, they can be filed, but we're not sure what's going to happen to them once the courts open back up, if the tenant would have to refile another case, or if it would be in line faster than other cases. It's hard to know. So a landlord claiming I need to spend a bunch more money to sanitize your rental when you're leaving is going to have to show somehow that the tenant caused damage beyond ordinary wear and tear. And we don't know exactly how that would play out, like I said, going forward in courts, because we haven't had a chance to see it because those courts are closed.
This question, I think, is about when, when can privacy, when can a landlord enter? 2-part question: can a landlord enter for showing the place to potential renters? How about for making repairs or do inspections that are routine but not emergency?
Yeah, so privacy, let's just kind of cover the old version of the rule first, which is that a landlord couldn't enter a rental unit unless they had 2 things really. First, they had to have a reasonable business purpose to go in. Second, they had to attempt to give reasonable notice. That's what's in the law and has been so since the mid-90s. Reasonable is a word that pops up in that statute a few times. The amount of notice isn't defined anywhere in many states, and this is what we generally talk about in landlord-tenant law, is state law. Many states state the specific number of hours before a landlord can enter. A landlord has to give 24 hours, or a landlord has to give 48 hours. In Minnesota, it doesn't say that. It says reasonable notice. What does that mean? Hard to know. Overnight notice is, in most situations, probably going to be good enough. But the statute also has some other pieces built into it, including a 3-word phrase that up until 6 weeks ago we didn't really focus much on in our line of work, which is under the circumstances. That the landlord's right to enter is analyzable under a lens of what's reasonable under the circumstances. And so the question becomes now, today, under the circumstances that we have, does a landlord have a right to go in? So if a tenant asks for repairs to be made and they really want the repairs to be made, I think the landlord can certainly go in. Just like if a tenant wants to invite a guest in right now, they can still invite a guest in. The tougher question is when it comes to showings. The tenant is given a notice to vacate for the end of May, for instance, and the landlord wants to start showing the place to prospective new renters to get it leased up for June 1. The old rule is the landlord could certainly have a right to do that as long as they gave sufficient notice to come in. Under the circumstances we're in, there's a better argument for the tenant to say, actually, no, I'm not going to let you in. The landlord's old remedy in that situation would be to go file an eviction, saying that the tenant was interfering with their, business practice or something like that. Some kind of breach of the lease, arguing something sort of like that. And I'm not sure how this would go if a landlord did file an eviction. If they could file an eviction right now, they might lose that eviction, especially if the tenant has higher risks. They're elderly, or they've got some sort of respiratory condition or something else that makes their immunized system compromised. It's a difficult thing to guess about, but we do know that some tenants are simply refusing to let their landlord come in. They are doing everything they can to help with showing virtually, taking a lot of still pictures and a video if the prospective applicant wants to see that. And normally, I'll be honest, we tell prospective tenants never to take a place without seeing the place that you're about to move into. But that's not really the advice we're giving right now under the circumstances, just because we're also concerned about having any contact with any surfaces. Now, if a landlord insists and a current tenant decides to allow the landlord to come in and do their showing, it's best to follow sort of the realtor's approach, which is tell the current tenant that they should have all their lights on, so nobody has to touch a light switch that doesn't live there. All the doors should be open, like to closets, to each room, to the bedroom, to the bathrooms. So nobody has to touch anything to see what's in there. And I think it's legitimate for a current tenant, to insist on the landlord and the prospective applicants to have masks on and gloves, and try to keep everybody as safe as possible.
And the next question is about financial assistance. Are there options available for financial assistance related to rent payments for tenants or for landlords?
And I'll let you jump in on this one, Eric. You've been doing a lot more work in that field than I have, where I just look at the laws.
So there's a lot of different resources that I think are oversubscribed. Minneapolis and St. Paul had their own bridge fund and gap fund that were covered in the news recently of having just thousands and thousands of applicants. But there's a couple places on our website. We have some links to places that tenants can go. We have a specific COVID portion of our website that we can direct folks to in a follow-up email, and that has some links to other resources. Counties throughout the state administer their own funds for emergency assistance and housing assistance, and several counties have approved or in the process of approving sort of additional emergency funds for rental assistance and emergency assistance. So I think sort of a general advice. Cities, there's some cities that have been doing this too. Like I said, Minneapolis and St. Paul that have their own city-based funds, but then there's also some communities that are passing assistance along to nonprofits, service agencies that are then handing it out in forms of rental assistance. So our general advice is check with your city and your county on what rental and housing assistance is available. There's also a number of places that can direct you to how to apply for unemployment insurance. And there's a way that you can apply for emergency assistance online through DHS, Minnesota Department of Human Services. So we will continue to try to update our website to have links for some of those resources. And at this point, I think those are all the questions we got submitted in advance. So I think, Mike, you're going to start tackling those that have been submitted while we're talking, and people, participants, please feel free to continue to send in questions.
Right, and we do have some left over from last week that we didn't get to if we run out of questions from people that are coming in right now, but we do have quite a few questions already sent in. So the first one is from, and Eric, can you tell me, is everybody able to see the questions and answers or not? Is it just us?
I believe everybody, I believe participants are able to see them. You may have to click the Q&A box if you don't see it. But I think maybe just read it out.
Right. I'll probably just say the first name of the person that is submitting it, just so they know that I'm looking at their specific question. So the first one we got was from Amy, and her question is, can a landlord accept partial payment for rent and evict tenant later on if this is written in their original lease terms? Amy, they probably could. Well, I mean, they always can file the eviction. The question is whether they win the case or not. There is a partial payment defense, which is a defense to an eviction that a tenant can try to assert. Many landlords on April 1, and I'm sure even more on May 1, are sending out partial payment, I guess offers is the best way to describe them, where they tell the tenant, look, I know that everybody's hurting, and I'll be happy to work with you on getting your rent paid. Let's figure out what you can pay, when you can pay it, and in exchange, if you sign this partial payment agreement, I will waive your late fees. So late fees, which are capped at 8% in Minnesota of what the tenant owes, are not disallowed by the governor's order. Late fees are still something that can be charged under the governor's moratorium on evictions legally. They are not allowed under the CARES Act. And so is that offer from a landlord to waive the late fees meaningful? It can be, but it might not have much real meaning. You might get that anyway through the CARES Act. But if the landlord and the tenant agree to a partial payment agreement in writing, where the tenant says they'll pay a certain amount by a certain day, and they live up to it, usually how these partial payment agreements are drafted is it's 2 or several payments that the tenant agrees to make by certain dates. And if the tenant lives up to that agreement, and then the landlord were to go try to file an eviction later on, let's say the moratorium gets lifted on May 13th, and on May 14th, they say, oh, we don't have all the rent yet, but the tenant has been making all the payments that the landlord and the tenant agreed to, that would be a really hard case for a landlord to win, showing that they tried to negotiate a new version of rent being due and when it's due and how it's being paid and things like that. For a court to say, oh, we're going to let the landlord get out of that deal that they'd agreed to when the crisis started, I would not want to be a landlord lawyer trying to argue that that's something that an eviction should hold up for. But thank you for that question, Amy. Okay, got a question from Linda next. So there's 2 parts to this. The rent strike and the banks giving slack. So let's start with the rent strike. So for May 1st, there's controversy. IX says to go on a rent holiday, rent strike. Commissioner Ho of Housing says, please do not withhold rent if you can pay. Governor Walz doesn't want landlords indisposed. So what does Homeline recommend about withholding rent in solidarity with workers of the world? All right, let's talk about that one first because it's a big topic. We get a lot of questions about rent strikes, rent withholding right now for, again, very obvious reasons. So if a tenant doesn't have the rent to pay the rent, that's a pretty easy question. They don't pay it because they don't have it. If they do have the rent, the governor's order clearly states that the rent is due. It's not a debatable question there. The governor's order says that the rent is still due. But the ultimate remedy that a landlord has against a tenant for not paying their rent is to file an eviction. And right now that remedy is simply not available to them. Will that remedy be allowed? Almost certainly at some point in the future. We just don't know when. What this question is really asking is, what does Homeline think that tenants should do? And it sort of implies that that's what Homeline does, is that we make recommendations to tenants. But that's not really what our tenant hotline does. I've been working at Homeline's tenant hotline since 1996. And my philosophy, and since I'm the managing attorney, I guess this is the hotline's philosophy as well, is we try to explain to tenants what options they have and what potential or likely consequences there are going forward. This isn't my money. I'm not going on a rent strike. The person that's calling me or emailing me with a question is the one considering it. And what I'm going to do is I'm going to lay out the options. Like I said, right now, a landlord couldn't take action against a tenant for withholding their rent, whether it's because they don't have the money or they want to make a political statement or for whatever reason they might have. But I assume that they will be able to file an eviction eventually. And then the question is, okay, if the tenant withheld their rent for a month or 2 or 3 and stands up in an eviction hearing and says, I was uniting with the workers of the world or whatever group they want to claim affiliation with, will that matter to the judge? Under the rules that we have no indication that that would matter to the judge at all. We just have no indication that that's the case. So I have been telling tenants that if they really want that to have any traction, the energy, I think, from a rent strike should be spent on trying to convince legislators that some sort of rent, either eradication or minimization, whatever it might be, instead of hoping that the judge ignores the laws, try to change the laws before the case ever gets in front of the judge. I think rent strikes are very difficult, but honestly, if not now, when could a group of tenants get something like that passed legislatively, whether it's at the city level or at the state level or at the federal level? I realize how much of an uphill climb that might be, but I've been asked about this question since this all started, since the COVID-19 outbreak started. How about rent strikes? Are they legal? Well, it's not like they're criminal. Nobody's going to go to jail over them, but what is a judge likely to do with these cases? And based on the rules that we have in front of us right now, I don't think it would be a valid defense for a tenant to say I was on a rent strike. And so it's a risky move. I would much prefer and advise tenants that if they want a rent strike to have any legal teeth, to try to change the laws through their legislative bodies that are available. The second part of the, go ahead,
Yeah.
Eric.
Yeah, two things to add on this. One, we do on our website, on the COVID section of our website, there's a section that talks about what if I can't pay rent, and it has links to some of the things from the previous question in terms of resources where you can find that. There is a section that says if I can't, what if I just can't come up with it? We have a sort of a sample form letter available there that tenants can use, and we know that tenants have been using them in some cases somewhat successfully. That basically it outlines the legal context for the situation right now. It talks about all the executive orders that relate to housing, and then it gives renters the ability to fill out some additional information in terms of what burden they're facing. For example, if they lost their job or whatever, and then it asks for some concessions of the landlord, a payment plan, the waiver of late fees, a number of other things. And it's you can download it and edit it yourself or edit it in Google Docs. So that's an option. We think that that's one of the stronger ways. If you're unable to pay rent, try to get some sort of thing in writing to the landlord and some sort of agreement. The other thing I'll add too, just sort of on a broader basis, is that there was a Senate, Minnesota Senate committee hearing last week where members of the committee actually pointed to members of their community who were rent striking and who they claimed still had a job. And that was used as sort of fodder for reasons why a bill should be passed to end the eviction suspension sort of as quickly as possible. So just know that that has different impacts in different ways, and but tenants are going to have to do what they have to do for their own situation. So the second part.
Right. Linda's second part of the question was, why are landlords and renters all suffering, but banks making business as usual? I'm not sure how much of this I can answer with my landlord-tenant legal knowledge. A lot of this is kind of a political question. But part of this question that Linda asked is, why are landlords and renters suffering? And they are. It is not just tenants suffering. We are giving a webinar tomorrow. We gave one last Thursday where we're talking to landlords, property managers. Again, we're a tenants' rights group. Why we are talking to those folks is we want them to understand what the rules are. We've given landlord speeches for years, mostly for that reason. We want landlords to understand what the rules are. They're more likely to follow the rules if they know what they are. But last week, and I know tomorrow, we're going to hear from landlords that are going to tell us that they're not getting paid. Many of them are not giant businesses. You know, it's somebody renting out half of a duplex, or maybe they own a fourplex, and they are starting out in the world of being a landlord and don't have a lot of financial cushion, and not getting the rent payment on the first of each month is endangering their mortgage. So there are definitely landlords suffering along with tenants. And well, I think banks are going to suffer too in the end. I don't know how long this is going to go on. Nobody does. But there's going to be foreclosures. And banks don't profit from that in general. So I think the pain is going to be felt in a lot of different directions. What I think societally we have to decide is how to distribute the pain in a way that we think is as equitable as possible, which is, I'm not being glib when I say talking to your legislator about whether a rent strike is specifically authorized, or maybe it's something more creative, like a landlord isn't allowed to file an eviction as soon as the moratorium is lifted. They have to allow a reasonable payment plan, and the statute tries to define what a reasonable payment plan might look like over 5 or 6 months even, which would be longer than most payment plans that landlords tend to agree to now. There's ways to try to deal with that politically, but again, the pain is in a lot of different directions, but renters definitely feel a lot of it, which is why the governor has taken the truly extraordinary step of saying no evictions can be filed. And that's happened in most states for good reason. We're talking to virtually the entire public right now, telling everyone, stay home. For everyone's safety, stay home. And tenants that are concerned that an eviction might be filed against them, they're threatened with an eviction, that's one push that they're getting societally. But the other push is to stay home. And so these conflicting messages that tenants are getting are difficult. And we try to, when somebody calls our tenant hotline or sends us an email on our tenant hotline, we try to look at their case and look at exactly what's going on in their world to try to figure out what they can or can't do going forward. Right now, that's about as good as we can do in our office, is to try to make sure that everybody understands the playing field and what the rules are. And that extraordinary step that the government in most states has taken to stop evictions right now is what is giving people at least current stability. The long-term approach, though, might require some legislative fixes. And look, in places like Minneapolis and St. Paul, there's more renting households than there are owner-occupied households. So if the people in those cities want to have their voice heard, their voice is bigger than the owner-occupied voices by numbers. And so it's a matter of talking to elected officials to see if there's some way to try to make everybody less nervous about what's next. And especially renters, because they're the furthest ones down on that chain that we talked about, the bankers to the landlords to the renters. And so they're the ones that are concerned about, am I going to be able to keep my home? Versus the landlord and the bankers who are concerned about profits. And I'm not trying to minimize the impact on bankers, but that is the question, and legislative asks from city council members, state officials are I think, worth the effort right now. Eric, anything else on that?
Nope.
Okay. Let's go on to Kasharn's question. And there's actually two questions here. They're separated, but I'm going to combine them into one. My landlord sent me a rent increase on April 22nd, so just a week ago, and said I need to sign a new year lease effective May 1. He also said that because I've not had a lease since 2019, although I requested one twice in the last year, that he could go and ask me to pay back month to month. Is this legal? Kasharn, short answer is, I assume from this question that you're a tenant, that you're the renter, and not somebody writing on their behalf, like a social worker of some type. I'd want you to contact us either by email. Is that on the screen right now? I can't see behind my, this is so weird, behind my face. There it is, yeah. Oh. Email us directly, and we'd like to see the documents as well that you have. The rent increase notice from the landlord, the old lease, any other correspondence, whether it's texts or emails, and then we can try to figure out what the landlord can or can't do. Obviously, I can start by saying the landlord can't do much of anything on May 1st if you refuse to pay more or refuse to sign the lease. They can't file an eviction for this reason. Doesn't work. But yeah, get in touch with us directly, because this is one of those situations where I want to make sure we don't miss something that's critical going forward with your situation. Next question is from Audrey. In case of undocumented tenants, exchanging work for rent is not legal. Could you advise? That could be the case if the landlord is following all the rules, I guess. People that are employed are supposed to be documented to through the government. That's why we all have to fill out the forms. I'm blanking on the name of the form. Eric, what is it called? The W-2, W-9? I can't remember which one it is.
No,
When you get employment, you have to verify your status. And that's one of the ways that undocumented immigrants have been discovered historically, is through employment. But I'm sure there are lots of undocumented immigrants who are working for landlords to some degree, whether it might be something as minimal as mowing the lawn and shoveling the snow in the winter, whereas simply in the lease, or maybe it's just a handshake agreement. So I'm not exactly sure where that question is headed exactly. I'm sorry, it's an I-9. Just got the information from somebody. Thank you. I do landlord tenant law, so I know almost all those statistics and citations, a lot of them by heart, but you move me out of landlord tenant law, and it's something that I'm not an expert on. All right. So next question is, again from Linda, is any unauthorized rental occupant given tacit approval, ongoing, if the landlord accepts rent for May? So, okay, I get the question, and it's kind of back to our unauthorized occupant living in a place. The landlord accepts rent on May 1st, knowing that an unauthorized occupant is living there. That is what we in the trade refer to as an ongoing or continuous breach of the lease. So there's all kinds of breaches of the lease, but if you think about something like a giant party, wild party with a keg and all kinds of noise, police get called out because it's so loud, that would be a one-time breach versus an ongoing breach, which is usually an unauthorized occupant or an unauthorized pet. In those situations, if the landlord accepts rent knowing about the unauthorized occupant, they have waived the right to evict for that ongoing breach, pretty much in perpetuity until they decide to start enforcing it again. I think this was the first case that Homeline ever represented somebody at the Court of Appeals on. And the end result of the case was that the court said, the landlord can't just keep accepting rent from a tenant knowing that the unauthorized occupant is there again and again, month after month, and then just snap their fingers and say, aha, unauthorized occupant, we're going to go file an eviction for that breach. You got to warn the tenant. And the concept that the Court of Appeals essentially came up with was fair warning. It'd probably be a full rental period's notice. So if the landlord wanted to say right now, today, let's just assume that we're not in the COVID-19 world, hey, I know you've had your boyfriend living with you for a long time and I've been accepting the rent knowing about it, but starting June 1, if he's there, I'm going to go file an eviction for unauthorized occupant. That would probably be enough time, especially if it's in writing for the landlord to say that. I think that a landlord could file an eviction eventually, maybe not right away, if they're accepting the rent knowing about the unauthorized occupant. All right, so next up is from Amy. Can landlords force a tenant whose lease ends in May 2020 to leave the unit if current tenants are still holding over to prevent homelessness, but the landlord has another tenant lined up already to move into the unit? Also, would landlord be able to sue later for costs for staying in the unit, especially if there's another family waiting to move in, like having to put the next people in a hotel? So yeah, I assume from Amy's question that what we're talking about is May 1st. And it doesn't really matter if the governor extends the order, we'd be talking about May 31st. But let's say we're talking about the end of April right now. So May 1st, we've got a current tenant still in the place. Prospective tenant is supposed to move in on May 1st. The landlord can't evict the current tenant. We've already talked about that quite a few times. But are there potential costs for the remaining tenant? Yeah, I think there are. I think there would be what we would call consequential damages the landlord could go after the current tenant for eventually. Again, not right now, but they could sue later on once the courts are open again for money. So thinking that through a little bit into the future, yeah, the prospective applicant might back out of the deal completely. So the landlord might lose that lease. And if the current tenant stays through May and they pay through May, maybe the landlord doesn't lose any rent if they re-rent to somebody on June 1st. But that prospective tenant, the one that was going to move in on May 1st, might have a claim against the landlord for some other costs. They're staying in a hotel, which Amy mentioned. They have the rental truck for a couple nights extra while they look for a new place to live. Those consequential costs from the prospective tenant, they could sue the landlord for, who I think in turn could sue the current tenant for later on for a money case. That would probably be in small claims court. It wouldn't be an eviction necessarily, unless that tenant, I guess, is still there going forward. But that would be the potential additional downside for a current tenant that sticks around, is there might be more dollars owed. I think that's realistic. What we're telling tenants in this situation to try to do is, if they know they're going to stay, to let the landlord know as soon as possible. I realize today's the 29th and tomorrow's the 30th. Somebody's supposed to move in on the 1st. But if somebody knows they're not going to have a place to move to on May 1st, and they know they're going to stay into May, they're better off telling the landlord right now, I don't have a place to go. I'm going to be staying. Hoping that the prospective next tenant can find another place for May 1st. It is a strange world out there of vacancies. In some spots, there's a lot of vacancies. In other spots, there's no vacancies. But that prospective tenant might be able to find something else, minimizing the costs for everybody. And so I'd rather the tenant was upfront with the landlord about that than sort of hid the issue and hoped that it went away and didn't tell the landlord about it right now. Telling the landlord about it this afternoon might make all the difference between a bill coming later and the landlord being able to minimize the expenses here. Next up is a question from Anonymous. When is the first date a landlord could file an eviction? Well, and I guess we haven't talked about this at all today. A landlord can file an eviction right now, but only for a specific and limited number of circumstances. If there's drugs found in the rental, illegal weapons, if the tenant is a danger to others, a landlord can file an eviction for that reason right now today. Now that's very few cases. I think the last time we looked, there were 2 active cases in Hennepin County right now. And so that's not a lot, obviously. As far as when can the landlord file an eviction for the other stuff, non-payment of rent, unauthorized occupants, holding over, at present, no sooner than May 14th. That would be the earliest they could do it, but the governor might extend the peacetime emergency. And if they do, then that would probably bump that out to June 14th or somewhere in there. And as mentioned earlier, if it's a non-payment case and the CARES Act is in play with that rental, there's a federal subsidy or there's some sort of federally backed mortgage, then it goes to July 25th plus 30 more days after that before the landlord can file an eviction. So maybe the end of August, near the end of August, before the landlord could file an eviction. So that is our best guess as to when an eviction can be filed next by a landlord in almost all cases. Okay. So a question from Julie, what if there was water damage due to sewer backup and the tenant was forced to live in a hotel for longer than a week while repairs were being done? Is the tenant required to pay for both the hotel and the rent? Kind of built into that question, Julie, and this isn't really a COVID specific question, is what caused the sewer backup? It's a really legitimate question. It's one of those things that if I had the ability to, I would tell the tenant when the Roto-Rooter guy or whoever shows up from the sewer company to help, or the plumbing company to help unclog the drain, says what they found in the toilet or further down the pipes. If it's tree roots, I don't think the tenant owes for the hotel. I don't think they owe anything for the damages that might have been caused. But if it was the tenant flushing something down the toilet that they shouldn't have, we've had plenty of clients over the years that have had kids that flush toys down toilets for whatever reason. 4-year-old boys are the likeliest suspects when it comes to flushing toys down the toilet. They're apparently fascinated with the notion of what happens to a toy boat if you send it down a toilet. And so in those situations, it's probably on the tenant to pay for it. And they might have to pay, their rent would still be due in theory, and they might have to pay the hotel charge as well. But it's pretty case by case. We'd want to talk to the tenant more directly about this. But yeah, you've just followed up saying it was tree roots. I don't see how that's on the tenant to pay for any of this. If they didn't have a working toilet and they couldn't use their home for a week, I think the landlord should be paying for the hotel for sure in that situation. Next question, anonymous again. How would you go about finding out if your home is covered by the CARES Act? You know what? This is really hard to do. If you live in a big building and you know there's a federal subsidy, it's almost guaranteed that it's covered by the CARES Act. The harder question is if you're renting a single family home or half of a duplex or something like that. And it's not something that I'm not sure, I don't even know if it is findable by the tenant themselves without subpoenas and at banks and mortgage companies. In Michigan, and we've seen now in one county in Texas, the courts are requiring landlords, when evictions are going to be fileable, to state and affirm, swear under oath, that they are not covered by the CARES Act. So we're hopeful that Minnesota follows that lead, because landlords are probably the only party in the world that can get to the bottom of that question. In most cases, at least, can get there fairly quickly. It's the right question to ask, how to figure that out. Our hunch right now is that if evictions, the moratorium gets lifted on the 13th of May, that our advice would probably be to every tenant that's facing an eviction to say, hey, CARES Act, not sure if it applies to me, but I'm going to assert it as a defense until the landlord can prove otherwise. And so that's the right way to approach that. Eric, any thoughts on the CARES Act searching?
Yeah, there's a number of online resources. National Low Income Housing Coalition has a section of their website that we'll put in our resources. Maybe I can send it out to everybody via chat, but where you can actually search online for most of the larger complexes that are subsidized. And then yeah, I mean, I think there's this other question that just got sent in about if there's one apartment that has a voucher, one unit in an apartment, and the 40 others are not, is that covered by CARES? And I think that there's sort of like a big question out there about that and how some of this is going to get solved. And I don't think you talked about what Michigan has done, but Michigan, and now there's a number of other like county courts throughout the U.S. That are actually creating requirements so that evictions either can't be filed until there's the landlord has a duty to, in their complaint, provide information that they're not subject to the CARES Act, and even in some cases, like having to submit, mortgage paperwork with their eviction complaint to prove that they're not covered. So it's going to be a very complicated situation. So we'll put up that link, or I'll send it out in a minute here, that NLHC has. Do we have new ones, Mike, that are coming in?
It's all kind of tied in together to what we're talking about right now.
Yeah.
There was another question. Oh, what is the first day that an eviction can be filed if the emergency order is not extended? And again, the short answer, and I don't mind repeating this because it's maybe the most important thing we talk about right now, that would be May 14th is the first day I think that evictions could be filed. The 13th is when the order would expire. Unless the CARES Act is in play, at which point August 25th or 26th would be the first day that the landlord could file an eviction for non-payment cases, which in Minnesota is well over 90% of all evictions. And I imagine that number would be even higher once the eviction doors open for landlords, it's going to be a lot of non-payment of rent evictions.
We got another question from Kusharn, the tenant. We probably have your email address.
Yep, I just looked and we do have it, and I'll make sure that somebody gets back to you this afternoon. Yes.
Yep. I wanted to just raise that there is a pretty good article, and I'll maybe send this out, the link to a pretty good article in MinPost today. One of our staff members, Ivory, sent it over to me about this, the kind of calls for rent strikes and sort of what the politics around that and how it's impacting things. I think it's helpful for context. So we have no live questions. We have about 5 minutes left. So I'm going to jump back to some of the previous ones, unless somebody wants to submit a question. Actually, no, maybe I'll take a quick minute. We are, I think we're going to plan to try to do this weekly, sort of for the foreseeable future, as long as there continues to be interest, which there has been. And we may try next week for even a little bit more interaction than the live Q&A. I think we'll be able to allow people to talk on a one-by-one basis, ask questions that way.
Hey, I want to see their faces. I'm tired of looking at me.
Well, yeah, and that's reliant on people having
Sure.
webcams
Right.
and stuff. But we're hopeful that we'll have that set up potentially for next week. And again, we are going to send a follow-up email within the next day or two with some of the resources and links to our website. And also there will be a recording of this available.
Eric, we got another question. Somebody asked how many are attending this today. Was it close to 80 when we started, I think?
Yeah, I think we peaked at around 80 or 90.
Okay.
Last week we had something like 400. And again, we do have tomorrow, we are hosting another one that's sort of designed more for landlords and managers as well.
Right, we got another question that just came in from Chris. After holding the landlord meeting last week, what appears to be their largest concern? I'm sure you could guess this. Getting paid, when they think they're going to get paid. We know a lot of landlords because we've worked with them throughout the years, and what we're hearing is somewhere between 10 and 30% of renters didn't pay rent on April 1. I'm not sure how much of that got paid through April, but to start out with, it was a pretty big number. Not that we want this to happen, but our hunch is that May is going to be worse. Maybe I'm wrong about that. Maybe the stimulus check will be hitting people and they'll be able to pay their May rent, or unemployment will be coming through. But I assume that the April rent, a lot of people were paying with their last paycheck. They'd worked half of March or maybe all of March, depending on their line of work, but then lost their job, and or had savings saved up, and they used that to pay their first month's rent. But I assume that May is going to be worse as far as tenants able to pay their rent. And so I know that that's what landlords are going to be asking about extensively tomorrow, is when they think they're going to get some money. And look, every tenant that I talk to wishes they could get to their job and wishes they could work and wishes they could pay their rent on their own. But hopefully that will be happening sooner than later for all kinds of reasons that we're all hoping for.
And we got a submission about holding a seminar in Spanish. That's definitely on our list of things that we'd like to do. We actually held a sort of a private one for a number of organizations a couple weeks ago. But we have been getting a good number of inquiries from Spanish-speaking clients. And again, I will share my screen here and just remind people that that's how you can contact our hotline. The phone number, the main number, 612-728-5767, does also have English, Spanish, Somali, and Hmong language prompts, and we'll get you to the appropriate language line. And online, you can submit a question to one of our attorneys at that link. And there's also, at that link, there's a Spanish version of the form as well. So you can submit your question in English or Spanish.
Okay.
All right. Well, we will wrap up now that it's 9:30. I want to thank you all for
9:30. Is it
sorry,
9:30?
it's
2:30.
2:30.
Wow. Time is hard to keep track of right now.
Every day is a month. So thank you all for participating, and maybe we'll see you next week. And with that, we will end.
Thanks again.